We are live, sir.
Yeah. Hello, everyone. Good afternoon, and I guess a happy last day of the of January to all of you. Uh, looking at the way some of you are dressed, particularly up north, I can imagine it's very cold. Uh, Hopefully, the tide will change soon. Today, we are having a webinar on IP schemes and incentives for startups and SMEs. Now, this is one of the important areas that ASSOCHAM and even overall as a country, we are very much driving towards. Startups are a big growth driver in the country, and with the amount of innovation that they are doing, see, fundamentally, startups are going to innovate. That they're going to change the way we do things. They're going to introduce new products in the market, and that naturally creates opportunities for intellectual property rights. And thanks to the Startup India program, thanks to DPIIT's initiatives, we have various schemes and incentives. And that's what we'll dive in today. And today we are joined by Mr. Santosh Kumar Gupta. He's an assistant controller of patents and design at the Indian Patent Office. Santoshji, thank you so much for joining us here today. I'll just give a brief background about you, and then we can learn from you how startups can take care of various things when they're filing and what all incentives they can take advantage of. Now, Santosh ji is an engineer turned quasi-judicial authority, and he's working as an assistant controller of patents and designs at the Indian Patent Office in Delhi. He holds academic degrees in the fields of information technology, software systems, and IPR laws. He also holds a diploma in fostering innovation and commercialization of IPR from the Copenhagen Business School in Denmark. And he has been certified as an innovation manager by DANCERT, which is the Danish Technological Institute. Mr. Gupta has been working with the patent office for 10 plus years and has dealt with 3,000 plus patent applications in the field of computer science and ICT. And as a controller of patents, he has given highly appreciated decisions with regards to the patenting of computer science and ICT related inventions. Mr. Gupta has also functioned as a faculty at the Rajiv Gandhi National Institute of Intellectual Property Management, RGNIIPM Nagpur, for the various batches of newly recruited Group A officers of the Government of India and for public training programs in the field of IPR. He has also published scholarly articles on IPRs and disruptive technologies like blockchain. So thank you so much, Santoshji, for joining us today. I mean, and it's no wonder that due to your very technical background, you have such wonderful insights, and we look forward to learning from you today. Over to you, sir.
Sure. Thank you, Mr. Shah. Thanks a lot, and thanks to the whole team for this invitation and for this particular webinar. Let me just share my slides. I guess it is properly visible.
Yes.
Yeah. So when we talk about various schemes and incentives for the startup and MSMEs, first we'll have to think that why this suddenly so much importance being given to the startups and the MSMEs. I think just confirm once that the slide has moved.
Sorry, it has moved.
Yes, sir.
Yeah, great. So everything is all right for the today's session. That's great. So the first thing is that why we are so much focused about the startups and the MSMEs, particularly when we look that the kind of potential that our startups and MSMEs have. If we look our old data, data of around say for past 10 years, if you'll see that the whole startup and MSMEs ecosystem is on the verge of an exponential growth. And if you'll see what has been the share of the MSMEs for the past 10 years, it is hovering around 30%. Means 26% it dipped during the COVID era. Then overall for the past 10 years, it has been around 30%. However, the potential that government is envisaging is something close to 50% of the share of the whole GDP. And how that can be realized? These startups and MSMEs, they are one of the main pillar stones for the job, the employment in our country. At the same time, if we see that the kind of share that they have in the employment and the kind of share they have in the GDP, we still feel that the potential is not truly realized. And that's where it will be key for the dream of that $5 trillion economy that our Honorable Prime Minister has been looking forward to. And how that can be realized? That can be realized when we focus more towards the knowledge economy. Because if you'll see how the whole world, earlier the concept of land, labor, and capital being the driving force of an economy, this is something which is a dated concept. Now it is the knowledge which has surpassed the importance of the land, labor, and the capital. And when the knowledge itself becomes capital and knowledge itself becomes the driving force, then the potential and the future is something which is not something which will be beyond the expectation of what we have all seen. So ultimately, if we see, the whole ecosystem is so right that we are looking forward to a great exponential growth in this particular field. And particularly when we look at our demographic, the Indian youth, which is going to be the flag bearer of the growth, we'll see that the green shoots of this, all the things that I'm talking about, they are already visible in the economy. That we are moving towards knowledge economy, and incidentally, 2022 was a very nice year. The last quarter of 2022 was the year when we saw that the share of the patent applications that have been filed by the Indian applicants, the last quarter of 22, it was more than the foreign applicants. So this is something to be something to feel proud of, because 12 year before, the data was around 17%. The share of the Indian applicants in the filing of patent applications, the share was around 17%, and 83% were the applications which were coming from the applicants which are foreign nationals, foreign MNCs, and even the individuals, they were from the foreign side. This particular shift is very heartening, and this is showing that what kind of potential we have. Then we come to, when you will see my slide, one thing that has been shown in the sun is like frugal innovations. Frugal innovation is something which is our real strength everywhere, because of the kind of demography, the kind of the per capita income that we have, and the kind of diversity and the challenges we have. This is something which is going to be paramount. And frugal innovation is what makes us unique. Even when we talk about our big this COVID vaccination scheme, if we had relied on only on the foreign schemes, the foreign things, if you will all remember how the initial reports were coming, that when the Pfizer or some other companies, Moderna and all, they came up with the vaccines, they were talking about that, okay, the logistics, we need to have minus 80-degree, then only it can be transported and all. So that's what I mean to say is, the solutions that we have in the world, particularly in the Western world, are something which are not so much useful for us because of our unique nature, the demography, the diversity. So that is why the frugal innovations, the innovations which needs the contextualization, particularly in the Indian context, they are of very, very important. And their importance is what that is going to be the key driving force on India. We all, whatever little we know about our Indian economy and the Indian system, we all know that it's very unique. A solution which has been tailor made in some other country cannot be applicable, and that is where we see a lot of potential for the country. If someone says that, okay, even as simple as say a vaccine for a disease XYZ, or say innovation for killing the mosquitoes, let's be very I don't think that an invention for preventing the bite from mosquitoes that can have so much use as spread use as in as a country like India as in any other country. Because in India, this is something which huge populace gets affected with that. So if someone comes up with that solution, that is something which has got its own incentives. What I want to say is that India, because of its unique nature, its unique problems, and unique demography, we all are surrounded with so many possibilities of coming up with innovations that it's unlimited. And that is why we need to keep this in mind that frugal innovation itself is the biggest incentive that we have. Then, when we look upon that, what is the importance of innovation? Of course, I talked about that the old concept of land, labor, and capital is being taken over by the fourth pillar, and that will be the main driving force, which is the innovation. So innovation always plays a very strategic role. It's not just that you'll see the economic growth, it will always have the strategic importance. And particularly when we have a contextualization problem, that a solution which has been developed in a country like say US or the UK or the Europe, that solution may not be the most suitable solution for our part of the world. So our problems, our solutions, they need to be tackled with the brain that is there in our country. And that is where the startups and the MSMEs, they become very important. And for them to survive, because see, the problem with IPRs are, it's like you can say that you may ignore it, but even if you ignore it, you'll not go far away. Because if you are not prospering from IPRs, then you are today or tomorrow you are going to infringe someone else's IPR because someone else is going to steal that. And today you may say that okay, I'm not interested in IPR. This is you can say a very foreign concept. It is not related to us. But tomorrow your idea will be stolen by someone else, and when that person will bring infringement suit, that is where the real problem will come. So why this IPR system innovation, and we are talking about the IPs and all? Because ultimately you need to have some ownership. Once you have ownership with your intellectual prowess, then that benefit holder can utilize it commercially. And this is where the real balance gets created, because you are giving a solution to an innovative solution to a problem that society is facing, and in exchange of that you get a monopoly right, and that monopoly right is going to help you. And when these are, I'm just starting from the basics just because to have this context from where we are coming, because ultimately then only you'll be able to appreciate that why we are talking about so many schemes, why we are talking about so many awareness schemes or programs and reimbursement schemes, a lot of things that is going on. So ultimately everything is about first making people aware of the importance of IP. And second thing is that once you have become aware about what are the IPs and what are IPRs, then how to get those rights and how to get associated with the ownership that benefit holder has, IP right holder has. And once you get that, okay, I'm the owner, I'm the rightful owner, and I want to work in this particular field, then your true potential get actualized, because nowadays the word is of the intangible assets more than the tangible assets. So ultimately it's about getting that IPR, first understanding what is that IP, and then getting that IPRs and taking benefits of various schemes that government has, particularly for the startups and the MSMEs. So let's start with the very basic of what is IP. So IP, of course, like any other property, it is a creation of human intellect. So whatever idea and its expressions that gets created by the human intellect and which has commercial value. That's important because excuse me. Normally, we tend to forget about the commercial values, and commercial value is important when we talk about what actually how our potential gets actualized. So you can have a brilliant idea, and if it is not of any commercial value, so then that IP will not be of that much importance. Ultimately, IP should be first thing that it should be the creation of a human intellect, and second thing it should have commercial value. And like any other property, even the intellectual property that can be bought, sold, mortgaged, licensed, exchanged, and we have various type of properties. I'll just touch upon that. And the main issue is the ownership of the knowledge. So either you become knowledge pirater, you become you do a knowledge piracy, or you prosper with that knowledge. The choice is yours. So you cannot simply become an ostrich. Just you close your eyes and you say that the problem is not going to come. So that is where the startups and MSMEs need to become more and more aware. I'm not saying that it will only be the patenting subject matter, but it can be as simple as a trademark. Yesterday only someone was talking to me and they were saying that I want to start a premium masala brand, the spices that we have. So I said, that's a brilliant idea. Go ahead. Then he simply said that, sir, I have an issue that I want to launch this with a particular brand, and but I'm not interested in just incurring any other cost to get it registered as a trademark or that logo and the slogans and all. So I was simply telling that tomorrow you are going to repent over this. If do you have faith in your idea? He said, yes, sir. I have faith in my idea. So I said that if you have faith in your idea, then you believe that your brand is going to become a huge success. So why not protect those intellectual properties? So he said that is it possible to get it protected even when it is not famous? So while talking to him, and he is one of the very closest relatives of mine. So I was thinking that, oh my God, first thing was that he said that, okay, is masale ka patent milega kya? So I first gave him a brief and then I told him, ki nahi, if you want to launch this masala brand, you should first get the trademark. So he was saying that it is an extra cost. I was making sure that when you are saying that it is my idea is a very brilliant idea, why then you are yourself doubting that no, I'll get it when I'll become famous. I said that this is a contradictory statement that you are making. So these are the things that, yeah, suddenly the next point that I told him that the problem is not that you are going to prevent others. Problem is that tomorrow if it becomes famous and tomorrow someone else gets registered, that person will sue you. So that's the main problem where we generally don't think. We generally think that अभी हम तो इतने बड़े नहीं बने हैं कि दूसरे को रोकना है. This type of thought process we go. But we forget that if someone else gets that protected, then that person will say that you are pirating. So this is what is intellectual property. So ultimately, when we talk about the creation of human mind and when we talk about the technological innovations, when it becomes technological, then only we talk about the patents. Because human mind, when human intellect can create many things. And human intellect, when it creates with regard to the technological innovation, then it is something which is called invention, and invention which is patentable. And when that gets patented, then again technological, it starts a virtuous cycle. Particularly this particular slide talks about that virtuous cycle, that when inventions happen, then you get it patented, then you get benefit from that, You get the growth in GDP, economical advancement happens, and then further enhanced expenditure in R&D. It's a very simplified way of a very complex process. However, in principle, this is what is believed that it happens. That once your efforts get rewarded, then whatever economic benefit that you get, that economic benefit adds on for further efforts, and that incentivizes your further efforts in R&Ds, and which results again more and more technological innovations. So how this IP system and development and this virtuous cycle starts. So the main problem is that when we talk about intellectual property, creation is not the biggest problem. Biggest problem is knowing how to establish that right and how to exploit that right. That is where the challenge is, because human brain by its nature, it's always creating some IP, even when we are aware, even when we are not aware, even when we are faced with some problem, as simple as how to sit on a chair which is very uncomfortable. Even there, we change our posture in such a fashion that it is little bit more comfortable than our normal posture. So human brain always creates something. When this sudden example, in even in fact without even thinking, I just gave this example that when we sit on a chair and it is not so comfortable, say it is a broken on one side, and then we change our posture, and we change our posture to adjust according to that. A normal human brain would be like, okay, we adjusted it and we'll forget that. A innovative brain will do that, okay, if some problem is there with this particular chair, then there can be another way of utilizing, another way of sitting there, whether that posture would be more beneficial to a human body. So that brain will start creating from that particular small action, from that small idea. This person will start thinking of a solution, whether I can design a chair which can take very less space, which can also be comfortable at the same time with a more simplified design or in a more cost effective manner. So if this is an idea, then how to get that idea protected? What is, if this is my IP, intellectual property, then what are different types of IP that I can get from this? Then comes the next thing. So it's like idea is coming every time, like when we speak, when we sit, when we talk, even when we drive. So every day if we go and analyze ourselves, we are surrounded with ideas. So those ideas, sometimes when these ideas are in the say field of literature, then we talk about the copyrights, literature or entertainment, songs, performers, right? So at a broad level, if it has something to do with your creativity and it is getting expressed there, then it is copyright. Say if you are writing a nice poem, so but and suddenly when something we design which has a very good aesthetic appeal. So if we are talking about the outer aesthetic appeal, something which looks very nice, very beautiful, then we talk about the designs, industrial design. Basically, the definition is industrial design. So these are different types of IPs that we are surrounded with. We have copyright if it is something of creativity, creative nature, literary skills, copyright. Aesthetic considerations, the outer look, then we go for designs. Then if we talk about the technological thing, something of technical nature, technical advancement, then we talk about the patent, technological innovations, then we talk about the patents. Then we have something like trade secrets where we don't want to share it with anyone, and we want to protect our rights. So we have trade secrets, but in India we don't have trade secret laws. In US we have, but just to know that this is also a kind of IP that we have. Then if you want to launch some brand and you want to have something to be associated with the kind of brand name and the value it is coming, like if I eat an burger which has this M logo, I know that it is coming from McDonald's. So at least I'll have this feeling that okay, it will have that certain taste and certain quality over that roadside burger. So something like we have trademark, and the example that I was giving, that I spices and all. So that person I was suggesting yesterday that why don't you go for the trademark? And then we have geographical indications. So likewise, we also have the semiconductors circuit and layout. And so likewise, we have several IPs. So what are different themes? So when we talk about today's topic, that what are the IP schemes, values, if we talk about the different types of IPs and different type of schemes. So those schemes, before going to those schemes, what is important is that first we should realize that what are the places where we need help. So first thing that we need help is that at least we should be aware of what are different types of IPs. Someone should tell us that what are different type of IPs. At least even this intellectual property is there. Whether uh, whether I can think beyond the land, labor, and capital. So even this awareness. So with regard to this awareness, various organizations are having various schemes and various platforms they are providing, be it CPAM, be it NEPAM, be it ASSOCHAM's various IP schemes, various IP awareness workshops, and various levels of ministries. In fact, various ministries like MIghty and DST, our own ministry, DPIIT, they have a lot of schemes. So first thing is with regard to awareness. Even MIghty has a lot of schemes. Second thing is that once you are aware that okay, something of IP is there, then the next thing comes that whether there is someone who can handhold you for allowing you to file this application in the relevant jurisdiction, because ultimately when there are IPs, there are certain laws which are administering it. And when there are certain laws that are administering it, then there are various offices which are working as the administrative bodies of that particular law. And those administrative bodies are bound with certain rules and regulations that what should be granted and what should not be granted. So as a person, as a startup or as a MSME or as an individual, when you want to file your IP application, how good it would be if there is someone to handhold you. So first scheme, there are certain schemes which are with regard to the awareness. Second schemes are with regard to hand holding, that okay, if you want to file it, if file it in this particular fashion. Then comes the next part, whether there are schemes where the fee can be reduced, whether there are schemes where, because we are talking about startups and MSMEs, so capital for startups and MSMEs is one of a crucial factor. Everywhere the money, since government has realized that IP, if we no matter how much we push to the startups and MSMEs, say ki file the patents, file IP rights, go for the IP rights, but until unless we incentivize you with regard to the filing fee, it's not going to happen, or at least it will take a lot of time to for the actual potential to get unfold. So first thing, awareness. Second thing, that there should be someone who is hand holding you. Third thing is that once someone has hand holded you, whether there are schemes which give you monetary benefit with regard to the filing charges. Then fourth, schemes whether the whole prosecution, the steps of a particular prosecution from the filing till the grant of the right, whether there is something which helps you. So awareness, filing, then fee, then prosecution schemes. So if these 4 5 things get covered, then it will be of huge help for the startups and the MSMEs. And this is how various schemes are designed. So when in a minute or so, we are going to directly jump into that what are different schemes and how they are incentivizing the process. But what is important is that we must realize that government of India, through its various bodies and various ministries and uh, various field ministries and departments, it is trying to focus on almost all the aspects of IP, from the awareness till the grant of right. Then comes the another aspect, whether our startups and MSMEs are so good that they have come up with some innovative ideas and they want to file a patent in the foreign jurisdiction, whether we have any scheme for them. So we have got, even for that, we have got certain schemes. And once we are aware of these schemes, then we can take good use of these things. And ultimately, this is what we are going to achieve. Again, I'll talk about the true potential, because every aspect is being taken care of. And that is why it is called the whole of government approach. The whole thing, instead, everything is being in silos, the things are being taken care. So a small brief that how various IPs are administered in India. Since there are IPs, there are various laws, and since there are laws, those there should be some bodies which particularly administer them. So under Ministry of Commerce and Industry, we have Office of CGPDTM, Controller General of Patents, Design and Trademarks, and there we have Patent Office, which deals with the patent applications, and patent offices are in the 4 metros. Then trademark registry we have for trademarks, design wing we have in Kolkata, and but you have got the facility of filing these applications online. So it doesn't matter that even if they are physically in those places, you need not to visit those places. It's just for your academic knowledge that these are the places where these offices are. Then you have got geographical indication registry, which is in Chennai. We have got copyright office in New Delhi, and semiconductor and IC, that is also in New Delhi. And then RD and IPM is basically our center of excellence when our officers get recruited. The training and even the public trainings happen there. Then we have got CPAM, and appellate board has been abolished. So in this particular website, in this particular site, this slide, the appellate board part needs to be removed because it has been abolished. So appellate board is no more. Now the decision of a controller is challenged in the High Court directly. So now we'll talk about what are various schemes. So first scheme is SIPP scheme. So this is basically the scheme for facilitating startups for the IPR protections, the IP protections. And under this scheme, what happens that there are certain facilitators. These facilitators do the hand holding part. So when I talked about, the first thing was awareness part is being taken care, as I told you, that CPAM, NEPAM, National IPR Awareness Program, we have CPAM, we have various bodies, industrial bodies like CII, ASSOCHAM, FICCI, various awareness programs are organized by them. The DSTs, the MITs, various ministries. So awareness is being taken care, even at the school level, the awareness is happening. Now comes when you want to have hand holding in the filing. So, yeah, someone wants to say something?
The accident.
Sir,
Okay.
please continue, sir.
Okay, sure. So when we talk about that some hand holding, that hand holding first scheme is on SI.
Sir, we have unmoderated, sir. That actually builds engagement. But please continue, sir. I mean, somebody has not muted their.
Okay, no issues. No.
Kindly mute. Please do mute. This would really help other listeners.
Okay.
Parul, can you mute the participant? Thank you so much, sir. Continue, sir. I mean, it is just. I mean,
no issues. No issues.
yes.
So the thing is that first scheme is SIPP. So under SIPP, we have got facilitators. So what these facilitators do, these facilitators will help startups to file and process their patent application, design application, and trademark applications. And their professional fee is given by the office, by the ministry, by government of India. It means that the startup is free to file it, need not to take care of their professional fee. So this SIPP scheme was launched in 2016 and it has been extended till 31st March 2023. And in line with this particular scheme itself, extension of this has been called something IP Mitra. IP Mitra concept has been a very recent concept. Particularly, it was coined on 19th of January 2023. So it's just around 10 days ago when this particular concept got a shape. So IP Mitra will be very much similar to how the facilitators were working, but at a more broader level. So the reach of facilitators will get increased through IP Mitra. So ultimately, these IP myths will be helping the startups in filing their patent applications, the trademark applications, and the design applications. And their professional fee, the professional charges that will be paid by the Office of CGPDTM. And there are certain, I have given the links also. There you can go and see, even if someone is interested to work as IP Mitra, then even they can utilize this particular facility. And this particular scheme and how people can utilize it, all the details is given at the IP India site, ipindia.gov.in at SIPP scheme. You'll get a lot of updates also there, because this scheme being very popular, it has seen a lot of updates also. So you can directly go there, you can see that how the charges and everything are changing and everything. But main idea is being aware of this particular scheme. That once you are aware of that, okay, something of this sort is happening, it is there. So startups can utilize this particular facility. So this IP Mitra is, since it is a recently launched concept, so a lot of things is happening in this particular field. And IP Mitra, basically the facilitators, they'll be known as IP Mitra with more, you can say, broader reach. They'll have broader reach to the people and bigger mandate, and more people can become eligible for IP Mitra. Then next thing is the rebate for filing of the patent application fees. When we earlier, it is around a couple of years ago when basically the fee for startups and MSMEs got reduced. So this particular thing, that the patent application filing, that has been reduced up to around 70 to 80%. The fee has got reduced. So they have become, startups and MSMEs are being treated at par with the individuals. So this is something which is a huge change, because if an individual need to pay say X rupees, now the startups and MSMEs are being treated at par with them, X rupees only. So they have got this huge incentive. So this is one of, like I was saying, that the whole cycle, awareness has happened and holding has happened. Now we are talking about the fee. So the fee is also happening, that okay, the fee is at a reduced level. So then comes the next feature, next scheme. Next scheme is expedited examination for a startup and the MSME patent applications. So what happens that in patent office, the examination is, I'll talk about that, how the whole flow goes, how the examination happen, what are various steps. But there, because of certain legacy issues also, there are certain backlogs. So in the normal process, it takes a significant time, which of course government is working hard to reduce it. And they have taken a lot of other steps like recruiting various officers and all. But for the startups and MSMEs, you have got one particular eligibility called Rule 24C. under the patents rule. So under the patents rule 24C, startups and MSMEs can apply for expedited examination. So what happens under the expedited route? A patent application gets processed within 1 or maximum 2 years, not more than that. So it becomes very fast. And particularly for the startups and MSMEs, they were added. Basically, startups were at the beginning in the 2016 only, but the MSMEs, they were added. Yeah, I'll take the questions one by one. So you can post it in the chat box and I'll take it. So yeah, basically what happens that expedited examination is something under the normal examination parlance itself. It is a request which you can file. So normally a request for examination is filed on form number 18, while for the expedited examination, you can file a request on form 18A. There you need to take on what basis you are filing, because there are certain criteria like startups, MSMEs. If all the applicants are individuals and any one of the applicant, at least one of the applicant is a female, then also they can file a expedited excuse me, they can file a expedited examination, request for expedited examination. Then if it is a government department, then if you have made India as a ISA in the International Searching Authority, when you file in the through the PCT route, you generally file for one ISA, International Searching Authority. And if you declare India as an International Searching Authority, then also you can file for the expedited examination. So for today's talk and today's context, what is important is if you are MSME or you are a startup, then also you can file a request for expedited examination by filing form 18A and paying the requisite fee. Your application will get expedited, and through expedited route, your application gets processed much faster. Okay. Then, excuse me. The next thing that I was talking about, that we also have a scheme, and that is by the MIT, Ministry of Electronics and Information Technology, where they provide support for the international patent protection in field of the electronics and IT. So if you are filing a patent application abroad, then MIT gives you your compensates you for a certain around 50% of the expenses that have been incurred, because in foreign jurisdiction the cost is huge. The cost of patent filing is huge. India is probably the cheapest for the patent filing and the patent prosecution. In abroad, for the US and the UK and the EP, there the fee is quite high. So the support for international patent protection in the electronics and the IT field, that is administered by the Ministry of Electronics and Information Technology, and I have given you the link. There you can go and see the details, see in details that what happens. So basically, the purpose is that you should be aware about all these things which are available. So when you are filing in India, you have got IP Mitra concept, you have got SIPP concept, you have got reduced fee, you have got expedited examination. When you are filing outside, then you can take benefit of this particular scheme, SIP EIT scheme. Then even for the universities, the government has given guidelines, particularly for there are certain startups which get incubated in the universities. So for them, they have got this how much royalty sharing and all. So there is a guideline which is there. So even if some startups get incubated in say IITs, now this is the latest trend that we are seeing. Even in India, people file a lot. So a lot of startups which have been incubated in IIT Delhi, in IIT Kanpur, in IIT Kharagpur, they file. So they have got this royalty arrangement and all that. What are the certain type amount which will be paid by which means the IIT, and what will be paid by the startup. So there is a guideline also. And then you also have
नहीं, हम भी चाहते हैं कि उस तक पहुंच जाए. तू नहीं चाहती, तू भी तो चाहती हुई है.
So there are certain IPFCs. These are the facilitation centers. So basically, these facilitation centers, they enable the SMEs and startups. So India has got a lot of IPFCs, and you can see the list of IPFCs just simply by even doing a Google and all. So you can see the CPAM has got a list of what are the IPFCs that help. DPIIT website also has got the IPFCs list. So this particular list is going to help you that if a startup and MSMEs want certain help from the IPFCs, they will help you regarding filing of your patent applications. So these are certain schemes which are of very much importance, particularly for the startups and the MSMEs. When we talk about, let's educate ourselves a little bit about how a patent application gets processed. So from filing to the grant, an application is filed. So you can file an application in the form of a provisional application, and within 12 months from that, you can file the complete specification. Or you can directly file a complete specification if you feel that your invention is already, it has taken a good shape and you are good to go. So then after 18 months, a publication happens. So this 18-month publication is a by default publication. Nowadays, particularly for the startups and MSMEs, what happens, they file for a request for early publication. So you can file, you can pay a fee and you can file for early publication. So it gets published early. Why publication is important? Because a file is taken up for examination only when it is published. Without its publication, it cannot be taken for examination. First thing. Second thing is that tomorrow, if someone infringes your invention and you get a right to, you get a patent over that, then that particular infringement suit, once you file an infringement suit, the cost is calculated from the date of publication. So that is why the publication is important. And then once the publication happens, then if you file a request for examination, and that request for examination should be filed within 48 months from the date of priority or date of filing, whatever is there. And then examination process starts. The examination process, if there are certain requirements which are not fulfilled, then report goes from the office, which is called first examination report, and which has a lot of objections and all. And then once that first examination report you go through, you need to reply it within 6 months from the date of that first examination report. And if you want that this time is less for you and you want that to be extended by up to 3 months, then you can file request within 6 months itself, and then it can get extended. So basically you get a time of 6 plus 3 months. And then again, your reply is considered, and if it is found satisfactory, then the patent is granted. If it is not found satisfactory, then a hearing is given. Hearing is basically an opportunity of being heard before taking an adverse decision. So after the hearing, then again the patent is either granted or refused based on that. During this whole thing, from the date of publication till the grant, there should be at least 6-month gap. 6-month gap is there because public should, if someone from the public wants to oppose it, then that any person can oppose the grant of that patent, which is called pre-grant opposition. And after the grant, up to 1 year, it can be opposed by any interested person, which is called post-grant opposition. So these are the inherent quality checks that we have. These are the implicit quality checks. These are basically the whole examination process here has been little, you can say, expanded. This was what I was telling you, that formal examination, technical examination happens, and report of examiner. First, when the file is filed, then it goes to an examiner. That examiner looks into the file for the formal and the technical requirements, and then refers that particular file to the controller. Controller looks into the report of examiner, and best if the report is okay, then issues that examination report. and then applicant goes through that, and if applicant amends that application, then again examiners look into that, puts it to the controller, and then controller, if all the objections are not met, then offers an hearing, and after the hearing it is either refused or granted. And if the applicant doesn't reply to the office communication within 6 months and extends and 6 plus 3 months, then that application is considered abandoned. That it is called that it has been abandoned, deemed to have been abandoned by the applicant. So there are certain best practices in the patent examination, like there is auto allotment of the patent applications. So when you file in a patent application in the patent office, no one knows that who will be the controller and who will be the examiner of that particular field. This is automated to bring transparency as well as efficiency. And then provisional of expedited examination. This particular case is of mine only. I dealt this application, and this application was granted by me within 7 months from the date of filing. So this is the impact of expedited examination. So I saw this particular application, it was good to go, and then I was waiting for 6 months to happen. The whole procedure, sending the first examination, then sending the first examination report FER, then the reply from the applicant, then sending the hearing notice, then the hearing has happened. If you'll see, everything was completed by 15th June 21. And the application was filed on 24th Feb 21. So within 4 months, I had completed the process, and I was waiting for the 6 months to happen, because public should get those 6 months if they want to oppose. And finally, I granted on 9 September 21. So this particular application was granted in 7 months. So for the startups and MSMEs, that is where the real benefit is being taken care of by a lot of people. So our office is truly paperless office. So, and real-time update, you can see the file wrappers and everything gets real-time updates. You can see that if I give a decision today by, say, if I give a decision by say 4 p.m. today, by 4:30 you can see that okay, it is uploaded on the website. Even directly it happens, but it's just that time lag just because of the technical thing only. Otherwise, inherent quality check, because we have this examiner and controller system. So inherent two-tier system is there, and provision of pre-grant representation or opposition is there. You get to have a detailed first examination report, and you also get to have a speaking order. A speaking order, if an application is refused, then controller gives a proper reasoning that why he feels that it should not be granted a patent. So these are, so basically how to protect your IPRs. So first thing is set a goal, dream and imagine that, okay, you can do it. Write it down, experiment, develop and modify. When I say write it down, it means your application has taken a proper shape, at least file it. File it in the patent office, because the system that we have in patent office is first to file. जो पहले file करेगा उसका right होगा. Okay, so experiment, develop, modify, and construct your innovation. Until then, keep it a secret, because that is important. Ultimately, your invention, what you have filed, and in fact, this is such a pain. Many of the startups, they falter on this particular point, that they don't keep it a secret. They first tell the whole world, then tell the patent office. Then their own disclosure becomes a citation for them. So you get a patent when you tell it first to the office, because once it goes in the public domain, then it becomes a little tough to determine that who was the person who knew it first. So the common mistakes that are done by the inventors are they generally publish their inventions before even filing the patent application. They generally use their invention in the public and the commercial use before filing the patent application. So what happens, that goes in the public domain. Once this has happened with me, not once, in fact, 4 or 5 times it has happened with me, that invention is good to go, but the inventor itself has created a YouTube video with regard to that. And he has created YouTube video in say 2014. He filed it in India, he filed it in 2017. and his own YouTube video became a citation for his invention. So, and the third and most important mistake that people do is they wait for their application to be developed for the fully commercial use. This is not a right approach. You should not wait till it is ripe for the whole commercial working. You should file as and when it is at least developed to it has taken a concrete shape. Do not wait for it to be commercially ready. So because applying for the patent is important. These are certain links that I have provided in my presentation. These are the links of various websites which are of use, like IP India. From there you can go for the comprehensive e-filing and all. Then the Startup India, there you can get what are various government schemes for the startups. And then Mighty link I have given for this particular scheme that I was talking about. Then there is one PDF document which is very good read. It makes a very good read for the startups and the MSMEs. And then there are some random couple of sites. So thank you so much. Now we are open for the questions.
Thank you so much. This was so informative, Santoshi. I mean, and truly kudos, because we incubate startups at Qualcomm, right? So we've been running a program since 2016. So far, we have incubated 89 startups, and these startups have collectively filed for 350 plus patents of their own.
Great.
Most of them first filed in India, and then through PCT they apply for patent applications around the world. So of course, it's great to see this startup ecosystem. And the other is this is first-hand data. Like one of our startups, they were in our last year's program. They filed their application in April, and in November, they replied back to me saying that their patent has been granted. They showed me the grant receipt. So this is like first-hand data, which is happening with a lot of startups. And I guess the reason it might have taken 7 months again was to wait for that 6 month publishing.
Yeah.
So thank you so much, sir. And I think we have a couple of questions.
Sure.
And maybe we can start, from the top. The first one is there any scheme for startups to apply for foreign applications?
I think I have given answer to this, that the scheme is administered by Mighty. The link is there in the presentation. And this reimburses a cost of around 50% of the cost that has been incurred, or 15 lakhs, whichever is lower. So, and the eligibility and all you can see from there.
Sure. And just for context for everyone, we saw the problem that startups and researchers can face sometimes, that they may not have access to like experts who know everything about IPR. So a program was created in partnership with DPIIT and NLU Delhi. It's called L2 Pro, completely free to use. And the links for that have been pasted in the chat box, and we'll paste it again. You can find information about this MATI scheme as well. And that's, again, please apply for that, because a lot of times, these incentives are there, and, people are not aware of when and how to apply for those. So MATI is there. And if you have, I also encourage you to look at the state startup policies. So if you go to the Startup India web page, for every state, you will see different incentives. And some states provide incentives for patent filing application, and some may even provide incentives for foreign patent filing. So please familiarize yourself with all these incentives. They're a lot. The best time to invent in India, I think, is these days. So the next one, I believe you already covered that. It's from Rajesh, which is called the eligibility to apply for the SIPP scheme. Our research scholars who are PhD, doctorates, are they applicable, or is it just limited to registered startups?
Yeah, basically SIPP scheme, you'll see that it's the institution based. It's a lot of institutions that have been mentioned there, that they are eligible for the SIPP scheme to apply. But when you talk about the research scholar and PhD eligible, now when we have a new version of that, which is IP Mitra, you'll get a lot of more eligibilities. So very soon, this particular thing will have a very huge, you can say, the whole spectrum is quite broadened. So let's see how the IP Mitra thing shapes up. And announcement have been already made at on 19th January 2013, 23. So since the link and all is there, you can go there and you can see that how the eligibility and everything is expanding there.
Sure. And there's another question from the same person, which is there support for international patent protection in medicine and drugs like SIP-EIT? Meaning, is there an alternative to MATI? Because I guess MATI only covers that.
Yeah. Yeah. See, basically the thing is that for the medicines and drugs is still directly there is no scheme. However, since various states, as Mr. Shah was pointing, Karnataka and Tamil Nadu, they have very nice startup and MSME schemes, very good incentivizations. So those state websites you can visit and you can see. But directly, if you talk about that for the medicines and drugs, is still I don't think that there is directly at a you can say central government level there is something like that. But soon it should come, I think, because Mighty it was launched, so slowly it will expand to various other fields. See these schemes particularly, if you'll see, government sees it from the perspective of what are our key strengths. In electronics and IT, it is acknowledged that that is our key strength, and we can excel the world, and we need to file it in the foreign jurisdiction. But when we look our data with regard to medicines and drugs, it's more oriented towards the generics and doing the reverse engineering. However, recently, if we see, particularly this COVID situation was a true blessing in disguise for us as a country, because we came up with a lot of innovative solutions, and frugal medicines and the cost effectiveness became a center point. So slowly we can see a next phase of our medicines and the drugs era. So just we are putting just our fingers crossed.
So I'm going to change up the order to give others also a chance. Dr. R.C. Chippa asks, how can we correlate invention search? I guess this is prior art search with the help of various search engines. Because you'll be looking at probably WIPO has a database, IP India also has a wonderful prior art search capability as well as other databases. So how can one correlate the invention search?
I could not get your question. Could you please repeat it?
Doctor,
How we correlate? Let me read it. How we correlate invention search with help of various search engines, role of WIPO for filing patent internationally. Okay, great. That's a really good question. See, what happens that when you do a invention search, particularly on search engines like say Spasnet or PatentScope or even USPTO or even the Google patents, you come up with certain things. And then when you go to the closest prior art, after doing certain searches, you go for a certain closest prior arts. What you should do, that once you go to the closest prior art, try to look for the references in that particular application. So it will again point you to certain relevant fields where you were unable to go. At first instance, say there is one technology that I am searching. I may reach up to a point. Now I'll try to do a search on that particular field. Say one patent application came there. That patent literature, I can go that what are various forward citations and the backward citations there on in that particular applications. So again, I can go and see that what are the relevant things that is there. Similarly, when you look into the say WIPO patent family of that particular applications, that will also help you that what are various fields, what are various directions, in which directions you can go. So it's like search is never a linear search. That this is something which even in the patent office it is performed by the examiners. So I always, whenever I take their class and they freshly recruited ones, so I always tell them that the search is not something which happens in a linear fashion. You should use all your methodology, all your skills, so that you can go to more and more relevant fields. It helps first thing in searching. At the same time, it also trains you with regard to drafting of claims, that how your closest competitor had drafted his or her claim. So I think that it provides an answer to your question.
Yeah, thank you. I guess the next one. The next one is from Jitendra Kumar, which is how can one register as a facilitator under the SIPP scheme?
Again, you can see the link I have given. From that link, you can see that how the registration process. The whole thing is very properly elaborated. Even for the IP Mitra, the logic is there. So you can see that what is the step. It's a very easy process that you can just go and register it. Only thing is that you need to be a credible person with verifiable credibility, because if you are applying for SIPP facilitator and you yourself is not qualified to do the filing and the process, how you are going to help others? So at least you should have certain level of knowledge of that. So if you are a bona fide user who has the capability to work as a SIPP facilitator, it's not a big deal, because you have a nice easy you can say portal where you can register with the relevant documents. You can go to the link that has been shared.
Thank you. The one after that, we won't take it. It's from Nibedet, who's an innovator we are very familiar with. He works in the area of medical devices, like very good innovations. But Nibedet, what you're asking for is actually a legal opinion, and this is a public call, so it's best to not get into that right now. Again, for this, you may want to just consult an attorney. Okay, a question for you, I guess, is from Deshmukh ji, which is, are there any hands-on training for candidates who have passed the patent agent exam to have practical training in prior art search and drafting? And if so, when, what is the training? So I'm not sure. RGNIPM, conducts a lot of these. Maybe you may want to share that.
Yeah. RGNIPM conducts a lot of public trainings with regard to this. And in fact, this was something which was there internally, that the talk was going on, that soon something will be launched, and RGNIPM will definitely be doing it. So you can get that information from the RGNIPM website. So basically, it will be the website will be ours only, the IP India only, and there you'll get the link for the RGNIPM programs, and there you can register and you can get the hands-on for the prior art searches and the drafting part and all.
I think we have covered all the questions, and if you don't mind, we can wait for a couple of minutes. I want to share just 2 or 3 slides on what L2 Pro is. This course has been today's session has been brought to you by L2 Pro. So I'm going to share very briefly what this course is about. And again, the pain point that it tries to solve is for innovators like yourself, who are looking for just a ready reference guide. It's not going to give you purely, like information on exactly how to draft a patent application, but it's meant for the innovator in you, which is to help you increase the awareness of and your understanding of the IP domain. That how can you think about patents, copyrights, trademarks, the different aspects of IP rights, as Santoshji mentioned during his presentation. If you're a startup, you'll have to factor not just one, but all kinds of IP rights. It's brought to you by DPIIT, by CPAM, by NLE Delhi, and by Qualcomm. And it covers the course in 3 modules. There's basic, intermediate, and advanced. And I believe everyone should be very familiar with everything in the basic module, which covers all the IP fundamentals. And then you have the intermediate ones where you get a bit deeper into the aspects of what goes on behind the scenes. As Santoshji was mentioning, what happens when your patents are evaluated by the various patent offices. how do prior art searches work? If you're a startup, you may have to consider how you build different agreements, different contracts, with your employees, with your vendors, and so on. And finally, there are the advanced level nuances, which applies towards, okay, how does fundraising work, considering IP? How do standards and standard setting organizations work? And an aspect of IPR tends to be dispute. So how do you go about these things? Now, at the end of each of these levels is an interactive exam, which is based on a case study. So it's going to test you a bit on the factual side, but will also ask you that here's a situation happening with a startup. What will you do in that scenario? The material is presented in a very informative, easy to use manner. For each lesson, you have an intro and a summary video about 2 minutes duration. So in my opinion, if you spend just about 5 minutes, you are done with about 60 to 70% of that lesson. And for a bit more for the reading, you go through each slide. And then at the end of each level, if you pass the examination successfully, you get a certificate which is provided on the spot. And this certificate is again given to you by DPIT, CPAM, NLU Delhi, and by Qualcomm. So I will share the link. I believe my colleague Anirban has also pasted the links for L2 Pro. You can access it on the web, on your phone, whichever device you use. L2 Pro is completely free to use. So over 5,000 users have taken L2 Pro, and we look forward to having you there. I've used it personally. It's a wonderful thing. I'm biased because I've been involved with that course, but it's a great reference guide, and that is particularly helpful for innovators and researchers. So if you can take one more question.
Sure.
One which has come up, which is, can someone patent for combination products? And this is something which comes up from startups also, which is, two things which may be already existing, but the combination doesn't exist.
No, combination you can bring, provided that combination leads to some synergistic effect. It cannot be like there are two things which are happening. There is product A and product B, and you are simply bringing them together. This is not patentable. But if bringing them together leads to some synergistic effect, which you show that, okay, once they are brought together, they lead to a totally new effect. They lead to more than it, which simply we say that 1 + 1 should not just be 2. It should be 1 + 1 should be greater than 2. So if that is greater than 2, then it is patentable.
Sure. I think we have covered a lot of the questions. Thank you so much for your very kind explanation, Santoshi, throughout your slides and even for the Q&A, as well to learn about the various initiatives that the India Patent Office has been rolling out. And it's again, my personal opinion is, if you are a startup or researcher, the best time to file for patents is these days. Take advantage of all these incentives, and like the expedited examination, the reduced filing fees, and just protect your innovation so that eventually you will get to commercialize them. So I think that's it for us from today. And on behalf of ASSOCHAM IPR Council, we also have an IP facilitation center. So on behalf of ASSOCHAM and our team here at L2 Pro, we thank you all. Thank you, Santoshi.
Thank you.
And of course, thank you to our ASSOCHAM organizers, which are Kirti, Parul, Nahid, Yashpal. Thank you a lot for the behind the scenes work.
Thank you all.
Bye. Thanks.
Thank you. Bye.
Thank you, sir. Thanks so much.